Sorry, we're a little bit late coming back into court, Mr. Harland. Now.
Yes, my lord, my lord asked me a number of questions earlier on in the day, and I just thought I'd try and give a few answers to them very quickly, and then conclude my submission. The first is in relation to the dates. I've had the opportunity of showing my learned friend a letter which was sent to the sponsor, and that shows that the 22nd of August 2019 was the date when the sponsor's licence was suspended. That's when the letter was dated to be sent to the sponsor. And that letter details that whilst there was an attempt at a compliance visit on the 2nd of July, the sponsor had actually moved address, and the compliance visit where there was an actual audit took place on the 4th of July 2019.
Sorry, I was just catching my notes again. 22nd of August, the letter.
Suspending the sponsor's licence. 4th of July was the effective compliance visit.
Thank you.
My lord also asked me
so could we be sent copies of that letter, please?
My lady, we will. I'll have to get them, I think, redacted, so it won't be...
Have you got... This is just an inquiry. Do you have copy of any compliance revisit notes?
There's details in the letter of the compliance visit.
The 22nd of August letter?
Yes, but there aren't. I haven't seen. There may well be somewhere notes in relation to that. As I say, the letter itself is directed to the sponsor. It still isn't part of our case, but this was any finding in relation to the applicant and his individual case, but it was in relation to the sponsor overall. My lord asked me in relation to the validity of the certificate of sponsorship for 3 months. I don't know if much turns on it now, but just to turn it up, it's in both the rules and in the guidance. In page 10 of the authorities bundle.
All right, just a moment.
Page 10, yes. And in the middle of that page, my lord, is 77C. And it sets out the various requirements for the COS to be valid. And at C, the sponsor has to have assigned that reference to the number to the migrant no more than 3 months before the application for entry clearance or leave to remain is made. My learned friend is correct to correct.
Right, C.
Yes. So it has to have been assigned within the 3 months before the application is made.
Yes.
And my learned friend is correct, perhaps, to correct any misapprehension from his updated skeleton argument that it's going to simply not be usable after those 3 months.
No.
The point is it has to have been used in the
application. It's not that at all. It's that it has to be... It's only valid for purposes of launching an application.
Yes. So
once launched, it doesn't come to an end. It's expire.
The point being that someone can't simply sit on a sponsorship application for many months and then finally deploy it at a later date. They have to use it within the 3 months. There are other points in the guidance. I'll come to them in turn. Yes, my learned friend raised the point about there being a need for reasonable grounds to investigate a sponsor, and he was referring, I believe, to 77H and 77J at page 13 of the authorities bundle. To make this point very briefly, because I hope that not too much turns on it, that 77H, again, just above the first hole punch on the page, it says, no points will be awarded for a certificate of sponsorship if the Secretary of State has reasonable grounds to believe, and and then goes on to say it's not a genuine vacancy. But that isn't the test for the investigation to be carried out, that is the test for the decision. So the Secretary of State only needs to show reasonable grounds for believing that something isn't a genuine vacancy. The investigation, the powers are set out in 77J, and it's just to support the assessment, the Secretary of State may request additional information and evidence from the applicant or the sponsor and refuse the application if the information or evidence is not provided. So that corroborates, perhaps, my Lord, what I was saying earlier on about the low level of suspicion required, the low trigger point for an investigation. There is no obligation on the Secretary of State to establish reasonable grounds to investigate.
So reasonable grounds for suspicion, as it were.
Reasonable grounds to believe.
Yeah.
If the Secretary has reasonable grounds to believe that the application is not for a genuine vacancy, she can simply refuse the application. So she doesn't need to meet a high threshold to refuse the application.
And so these are rules, aren't they?
These are the rules, yes.
So Rule 77H, information, and if not sufficient, can request information and refuse it if not provided. Yep. Thank you.
And coming back again to another point that my learned friend raised, which is in relation to this causation issue, which is the first of the arguments I'm going to raise in relation to delay, the one which we were dealing with just before lunch. My learned friend said, well, his point on delay arises from the 20th of May 2019, which is where he says that from the GSID notes, one can see that the decision maker is assessing the situation, and he says that at that point she should have taken a decision. And I say with respect, my Lord, that illustrates the causation point that I am trying to make, which is that if the Secretary of State had taken a decision on the 20th of May, what was it required to be? Does my learned friend say that on the 20th of May, because she hadn't reached a view on the suspension yet, she was obliged to say, well, I'll accept this application because I haven't reached a conclusion on suspension? And the answer to that must be no. She was entitled, if not required, to continue on with her investigation and work out whether there had to be a suspension of the licence and whether this was a genuine vacancy or not, for the good reasons set out in the GSID notes, which were the enormous increase in salary, just apparently at the drop of a hat. And then, on analysis, the fact that this seemed to be a very top-heavy organisation with a lot of managers, all therefore being paid above the threshold that they were required to meet so that they could get Tier 2 visas here, and fewer people lower down, and other points such as the debt and the like. We don't need to go through the notes here in detail. So the causative point then is it can't be right that what was the obligation on the Secretary of State was to take a decision on the 20th of May on whatever information was before her. Come that date, she was required to allow her investigations to pay out and see what came of them. Although in the event, they were superseded by the sponsor's decision on the individual sponsorship. I'm going to turn on to my second point in relation to delay, which is to try and set out what the case law says is the threshold before which the courts would intervene in a delay type case. My learned friend, I would say, hasn't been able to point to authorities which clearly support his case, that in a situation such as this, where there has been, for example, an error which is remedied on administrative review, that then must lead to a different outcome at the end of the day. And I do say it's right to touch briefly through the case law that we do have in the bundle, because there's a lot of it. and it does, in fact, guide this.
In fact, there's a lot of case law is not by itself enough justification for going through it all.
But we're certainly not in a situation where this court is in limbo with nothing to steer them. There have been many courts before this court who've gone down this route and explored what the threshold is. We started off with AO. I don't need to turn it up, I don't think, because that was the case that my learned friend relies on, say it has to be decided in a reasonable time. And of course that's right, but that begs the question of what reasonable means in any given circumstances, or, more pertinently, what amounts to unreasonable amounts of time.
Have there been any decisions of this court? Or are you really taking us to first instance? AO is in the admin court.
That's true. It's going to take you to the case of Shah, and
That's also in the
that's in the administrative court.
And FH, we decided was in the administrative court.
Yes. And OH, which is at tab 14, is before Mr. Justice Garnham. I think it may be that the authorities that I have taken this court to are all at that lower level, and that might be my mistake. But
it may not be your mistake. It may be that there isn't a decision when this point has expressly been this court has especially been which has had covered.
But these are now historic decisions, and certainly in the position that the Upper Tribunal Judge was in, there was settled law, I say, before him in relation to the delay issue, which he was perfectly entitled, if not bound to follow, in relation to what amounted to an excessive delay, and therefore whether his finding refusing permission was reasonable in the circumstances. Now, I will take your lordship, in fact, now to a Court of Appeal judgment, which is that of RS, which is at tab 3.
Okay.
So this is page 18 of the authorities bundle. It starts. And we've already been to this judgment in brief, I think. My learned friend would rely on 51.
Yes.
I'm going to take your lordship to paragraph 48, which is at page 33.
48.
Paragraph 48, yes.
Paragraph
page
48.
33.
Yeah.
And that says that the present case differs materially from Rashid. Rashid was the conspicuous unfairness case, which has been controversial since its promulgation. But for our purposes, it's the last 4 lines, perhaps, of that paragraph. In this case, administrative delay meant there was no such decision. Administrative delay in itself, even if it results in less favourable treatment, does not provide the basis for a remedy. And I'll go back to paragraph 41. Paragraph 41 at page 31 of the bundle reiterates this, because it's looking at the department's conduct. It says the court's proper sphere is illegality, not maladministration. If the earlier decisions were unlawful, it matters little whether that was a result of bad faith, bad luck, or sheer muddle. It's the unlawfulness, not the cause of it, which justifies the court's intervention and provides the basis for the remedy. Conversely, if the 2004 decisions were otherwise unimpeachable in law, I find it hard to see why even flagrant incompetence at an earlier stage should provide grounds for the courts, as opposed to the Ombudsman's intervention. The point perhaps being made here is that the simple fact that there's been mistakes made or incompetence previously doesn't mean that the court then should intervene just to work out what would have happened but for that muddle, but for that maladministration, and try and say what the outcome would have been but for that. So when one was looking at a delay case, one has to see effectively what the delay overall is. And I'm going to take the court to the case of Shah at tab 8 of the authorities bundle. and we're going to be looking at page 99 in the bundle. And paragraph 36, which again is the court, this is Mr. Justice Mitting, grappling with the Rashid case. And again, stressing the point that in a delay case, it's not simply a question of trying to work out what would have happened but for a wrongful decision earlier, or even in a wrongful decision case, it's not a question of doing that. What one has to do, so in the third line it says, it has been asserted that but for unwarranted delay, decisions more favourable to an individual would have been made so as to require the Secretary of State to make the more favourable decision which would have been made had the case been dealt with earlier. Then it details Rashid and then S and Secretary of State, which is the case we just looked at, and S, H and Q. And it says the true principle is now settled law. It can be summarised simply as follows. First, the Secretary of State is entitled to apply policy applicable as at the date of the decision under challenge. Secondly, the court is concerned not with maladministration but only with illegality, so that, that if maladministration produces a decision that's unlawful, that can be the subject of a successful challenge but not otherwise. Thirdly, there is no principle of administrative law that if the Secretary had made a decision earlier resulting in a more favourable outcome for an individual, then whatever the changed circumstances may be when the decision was actually made, that more favourable decision must be made. And that reinforces, perhaps by virtue of actually being case law in the bundle, what I was hoping to say earlier, which is that it simply isn't the case that what the courts are required to do is say, in this case, well, had the decision been taken 2 months earlier, what would the outcome then have been? One has to establish where the unlawfulness is, and even where there has been unlawfulness, it doesn't necessarily mean that what one has to do is put the individual back in a situation as if an earlier decision had been taken. I can, and I
So it's the thirdly that you're really.
I will
Relying
on
on
three, but
that.
thirdly, I think has particular bite given our discussion earlier on today. Can I take the court again briefly to FH? Which and page 44 of the bundle.
Sorry, page number again.
Page 44 of the bundle. This is the FH case. Mr. Justice Collins. The context of FH was that there had been a number of asylum claims which had been held back and delayed for a very long time. We're looking at a period of 5 years in the case of one of the appellants here. And it's in that context that the court was looking to see whether the delay was manifestly excessive and found that it wasn't. And at paragraph 11 on page 44, it goes on to talk about whether the delay was unlawful. And in the second and third line, it can only be regarded as unlawful if it fails the Wednesbury test and is shown to result from actions or inactions which can be regarded as irrational. And in the last line of that page, what may be regarded as undesirable or a failure to reach the best standards is not unlawful. Resources can be taken into account in considering whether a decision has been made within a reasonable time, but assuming the threshold has been crossed, and that must be the threshold of unlawfulness has been crossed, the defendant must produce some material to show that the manner in which he has decided to deal with the relevant claims and resources put into the exercise are reasonable. And it goes on to say that does not mean that the court should determine for itself whether a different and perhaps better approach might have existed. That is not the court's function, but the court can and must consider whether what has produced the delay has resulted from a rational system. And then it goes on to talk more about resources. But the point being, for our purposes, that what is being said here is that one has to show that the delay is Wednesbury unreasonable, or unlawful. And in those circumstances, where the threshold has been crossed, the defendant would have to then explain by pointing to resource issues why their behaviour has been reasonable. And the court then can consider overall the lawfulness of the situation, but it's not for them to say, well, you should have paid put X amount of extra resources into the system. And there's a helpful summary of these principles in my submission in the O&H case, and that's at page 213 of the bundle. This is the bottom of page paragraph 89. And this is reiterating some of the points that we've seen in FH, but it's drawing helpfully a distinction between, in Roman numeral 1, cases where there is an established status. So those might be cases where someone has been adjudged a refugee, but the Secretariat hasn't given them the correct forms or correct identity documents, so they can't take advantage of that. In those cases, delay will be treated differently. The cases where simply someone is applying for status, and the Secretary of State is having to go through a long queue to work out which of the individuals applying are entitled to status and not. And so the reality is, looking at all of this case law, there's a range of authority which is saying it's not enough to say this could have been done quicker, and it's not enough to say, well, that there's been muddle here. What one has to do is show that there's been effectively a manifestly excessive delay, and then at that point the respondent would have the opportunity to put in the evidence about the resources, and the court can then decide upon the lawfulness. But we're looking in terms of manifestly excessive, and there is no benchmark, but we're looking at periods in FH of 5 years, in O&H 34 months of delay, in asylum cases engaging convention rights, which were not found to be unlawful delays. And it's in that context, perhaps, that we turn to look at this case, because my learned friend is saying that the delay between May and August is an excessive delay, manifestly excessive delay, including the reality that in that time there had to be a compliant visit, and then there had to be an assessment of all of those different issues. And that doesn't even vaguely approach in my submission the threshold. And indeed, that's not quite how my learned friend put his case before the court below or in his skeleton argument. In those documents, he asserted that the issue was that verification had to be dealt with within a certain time scale, and so the Secretary of State had failed to comply with the obligations, or at least her timescales, by a significant amount. And those arguments were all based, I'm afraid, on false premises. The first is the assertion that the verification had to be done within 4 weeks. And my learned friend takes that from page 355, the last page of the authorities bundle, Annex B to the Secretary of State's guidance. But one can see from Annex B to the guidance that covers verification checks on documents. And that isn't the situation here. The Secretary of State is not asking for a simple document to be sent over and to say, well, this is true or not, this is a valid document or not. She's having to do a complex analysis of whether a business is wholly genuine or whether there is some degree of fraud involved in it. Secondly, of course, the fact that the Secretary of State demands a response from the sponsor by a certain date doesn't mean that she is undertaking to take a decision within the same timescales. It's perfectly reasonable for her to say, I need the sponsor to react quickly, but then have to deal with the queue of waiting applicants in order to, in a sensible way, in order to decide upon the application. my learned friend says there's that the Secretary of State is expected to act within a certain amount of time. Whilst we're still on the guidance, which is at tab 18, there are two paragraphs I would want to turn up.
Would you give me the page number, please?
Page 344.
I'm sorry, paragraph number?
Page 344, paragraph 206 of the guidance.
Yes.
This sets out what the Secretary of State tells applicants, which is, we aim to consider applications quickly. However, we must be confident that applications meet the requirements of the immigration rules and the information you provide is a true reflection of your background, which is clearly setting out that there may be a delay whilst checks are carried out. And likewise, at page 351, and that's paragraph 301.
So 306. And yeah,
paragraph 301, page 351.
Yes. So 306. Yes.
Sorry, it was
06 at
page 351. Yes, paragraph 301, my lord. The one at the top of the page. Any two-tier application submitted whilst the sponsor's licence is suspended will not be considered, even if the application is accompanied by a valid certificate of sponsorship. And it goes on to say, if the application falls for refusal on other grounds, for example, the job is not a genuine vacancy, we may make a decision.
Sorry, I can't see where you're reading from.
I'm sorry, paragraph 301 at the top of page
my mistake.
351. I'm sorry, I may have...
No, it's my mistake. Thank you.
Does my lord have that?
Yeah, I do. Can I just read it? Yeah.
My lord, so this this sets out really what I've already told the court, which is that when a licence is suspended, then the decision maker won't make a decision on any application unless he or she can decide it on other grounds which aren't related to the suspension of the licence. The example given is if the job is not a genuine vacancy, which might be glaringly obvious, even though the licence hasn't been revoked as yet. But another obvious example is if the sponsor has said, "I'm no longer going to sponsor you," in which case the decision maker will then be able to conclude the decision on the basis of the information that's been given, and not have to wait for the end of the suspension. So, my lord, that tallies with roughly what happened in this case, which is a decision would normally be made when the suspension was rumbling on, even if it hadn't formally happened yet. But in a case such as this, where there's another reason for refusing the application, it is appropriate, and indeed proper for applicants perhaps, for that decision to be taken promptly and communicated to them. And again, that's what happened here. So the suspension isn't mentioned in the letter because it has no direct relevance to the reason for the decision. And my lord, I've gone over my 20 minutes, which I stated I thought I'd be. Yes, all of this, I mean, none of the reasons, and I don't think they're pursued now, none of the reasons for saying that a quicker decision had to be taken on the basis of the guidance actually stand up. There is no such obligation to the guidance. The guidance is only sets out that the Secretary of State will inquire and then take a decision, either when she can or when the suspension has been decided upon. And as a result, we simply say that this isn't just isn't a case which gets near the threshold, that high threshold of manifestly excessive delay. It doesn't, in that respect, call for a response by the respondent, but the respondent has produced adducive notes. They're not entire. They're not all of the notes that we hold, but they are adequate, in my respectful submission, to allow this court to look at what happened and identify whether there are any periods of clear inaction when the Secretary of State is acting unreasonably by failing to do anything. And the answer to that is no. There are no such moments. None have been identified. And so the Secretary of State was entitled to carry out the investigation she did, and indeed she was vindicated, because at the end of the day, this sponsor's licence was obviously suspended and ultimately revoked. And so at no point can this applicant say that, but for the Secretary of State taking a while to investigate, my job would have been there and available, and I would have been able to start it. So my Lord, unless there's any further points, I know that we've been a little bit, I've been a little bit scattergun because there have been a number of points which have been raised. Unless...
Yes, Milady.
In paragraph 11 of your respondent's statement, there's a reference to fresh SCs. What's an SC? Is that a sponsorship certificate or something else?
So I'm having to turn it up because
you might
have noticed I didn't draft it.
No, don't worry.
Lady, I can inquire. We might be able to get an answer.
That would be,
I'm afraid the answer I got to the earlier question about an acronym was that...
Yes,
GVR.
Yeah, it's another. I mean, it's just another extract from the GCID notes, but it says the last line of the extract says fresh SCs requested.
Yes.
And in one of the documents, I can't now remember which one it was, there's an acronym BRP. You know what that stands
That
for?
would be a biometric residence passport.
Oh right, that's very helpful. Yes, I should have known that.
But I'm told that it would be my client informs me it's genuine vacancy or general vacancy, and the GVR, that is what that organisation would be.
Do we know what the R stands for?
I'm afraid not, my lady. I can certainly inform.
2 out of 3 ain't bad.
Yes, I mean it would be. You know, the R must stand for something, so it would be useful to know what it does stand for, please, if you're able to.
I'll try and confirm both of those and send them across as soon as possible.
Okay, that's really
there
helpful.
is also the redacted version of the sponsorship letter.
Yeah.
Thank you. Thank you very much, Mr. Harland. Yes, Mr. Barrett. Any
My
reply?
Lord, I didn't have any reply as such, unless there's anything that you wish me to deal with.
Thank you very much. Well, we're very grateful to you, both of you, for your submissions in this case, both written and oral. We're going to reserve our judgments. In the usual way, drafts will be sent out, a draft judgment will be sent out to counsel for typographical corrections and corrections of minor factual errors. You will bear in mind the guidance about the embargo on disclosure, wider disclosure of those draft judgments. I wouldn't want this to be the case where there had to be some unfortunate consequences for a breaking of that embargo. In due course, after receiving your comments, judgment will be handed down on a date to be fixed, and that will be, under the new dispensation, a remote handing down. There'll be no need for counsel to attend. If there are any ancillary consequential issues to be resolved, we'll deal with that in writing on the basis of further written submissions. Is that all clear? We'd be grateful when you send in your comments if you could do a draft order as well in due course. Thank you very much.